Assalamualaikum guys, welcome to my YouTube channel. Today the topic we are discussing is family law. What is family law? We should discuss this topic in detail. What is family law and its all things history and societies etc. What is family law? Family law bodies of a law regulating family relationships including marriage and divorce, the treatment of children and related economics matter. In the past, family law was closely connected with the law of property and succession. See property law and judgment from the record available. It must be originated principally in the economics and the property question created by the transfer of a family from here. Father family to the power and the guardianship to her husband. Even with the regard to relation between the parent and child, legal concepts such as a guardianship, custody, and legitimacy were associated with family power structures and family economics interest. Family law also traditionally has to do with matter of personal status. For example, the question of whether a person is to be considered married or a single, legitimate or illegitimate. Through the incident and importance of these decisions often derive from the law of property. Family law share an interest in certain social issues with other areas of law, including criminal law. For example, one issue that received considerable attention since the late 20th century is very difficult problem of violence within the family, which may take the form of physical violence by one adult member on another, or by an adult or an child, or some other violent or abusive conduct within a family circle. In serious case, the only real solution may be to terminate cohabitation or to remove an abused child from the family unit into some form of public or a foster custody. This article is a note a treatise on the family law of the world would require at least a volume, but a general survey of the common legal problem associated with the family. Family group. A family group has a certain internal structure as well as relationship between itself and third parties. Family groups in some societies have a tendency to be complex, as of for example the Roman paterfamilias group, the Chinese upper class family, Indian joint family, the samurai family in Japan, the two parent family. At present, the dominant from one of the family group consists of a two spouses and the children they have produced or adopted. The law therefore is concerned mainly with the right of the couple and their children and the duties of the couple to the children and each other in a strict monogamous society. For example, the law will be forbid a person to be married to more than one and other person at the same time, while in another society it will regulate the number of wives a man may simultaneously as the Islamic Sharia does. Traditionally, family has not concerned itself much with unions that are not commenced by legal marriage. Through some system of a law have permitted the recognition of a natural child by a father for a purpose such as the inheritance and sport. More recently, the family law of several European countries and of some jurisdictions in the United States was amended to recognize civil unions or domestic partnership, which created many of the legal incidents of marriage for same-sex couple and see also same-sex couple marriage. The one-parent family. In since 1970, one-parent family have acquired an importance not adequately reflected in the traditional law. It may be necessary to adopt the law to a greater extent. The need for one-parent family in areas such as the organization of a family and child welfare service and the legal and administrative machinery for family support, employment assistant, day nurses, and the like. The head of a single parent. The household may have difficulty affording the high cost of the children care while working or training, especially on a modest or a low income. Legal consequences of marriage. Two persons might produce the economic incident of marriage by the executing appropriate contracts or a settlement in some legal system. A contract in conventional form is the core of the constitution of marriage. The contract may be complex with a variety of clauses as Islamic law. In most countries today, however, the legal documentation of marriage is mainly a registration of the event. Basically, the marriage in the legal sense is implied creation of a certain rights or obligations such as the maintenance marital property and the succession right and the custody of minor children. In modern system, the parties to a marriage can usually create the economic incident of the marriage by a separate agreement in some early legal systems and in present system in which customary family law prevents, there is a little choice or to the economic incident of marriage because these are fixed by the custom in legal systems that allow substantial scope for personal independence. The spouse can take up a position for their own so to the economic basis of their family groups by means of a marriage contract or a will. One feature that distinguishes marriage from a simple contract that in many countries the parties cannot release them by mutual agreements, but some legislation in North America and Western Europe come close to the permit in this. The ground of divorce has been so widened that the marriage can be terminated, for example, after a period of a separation. See below device. Divorce. Children. It is almost universally the rule that the natural or adopting parents have a primary duty to maintain their minor children. In the great majority cases, the care and the upbringing of a child belongs to his biological parents automatically without regards to their qualification or suitability. No doubt this arrangement was due originally to its convenience and a lack of an alternative. Through examples may be found of a group rearing their children in commonly used in their tribal societies. The parental system also have been justified on a religious grounds. Legitimacy. By the common law of England and legitimacy, children was a filius nullius with relative. There may have been two main reasons for their former discriminatory attitude. First, certain union between the sexes were designed as a lawful marriage, and a man of a importance agreeing to his daughter's marriage would insist on her having the status of a legal wife. Second, paternity in legal senses was easier to establish in the case of a lawful marriage. Then, in its absence, the common law England, for an example, presumes in the favor of legitimacy when the children is born in the boneful wedlock, even if the biological facts may be otherwise. Civil law systems. Those derived from a Roman law have been less absolute than the common law. The provide ways to legitimating our children, such as through subsequent family of the parents or through an act of a recognition by the father. Modern statutes law has brought the positions in different systems closer together and remove some of the worst features of the doctrines of the legitimacy. Legitimacy is a concept dimensioning importance in the modern law, and even countries then still retain and have hugely modified it. They have done so basing sport obligation on a parentage rather than on a legacy, varied marriage, and by giving rights to in-state succession to children born out of wedlock by the legal devices of legitimation and adoption and by other means. The difference between the legal status of legitimate and that of legitimate children has been narrowed. Adoption. The ordinary legal principle is that the consent of a natural parent guardian is required for an adoption ordered by a court. This consent may be dispensed with if the natural parent or a guardian cannot be found or has been proved to be the uninterested or a cruel. Adoption in the elder Legal system, as in Roman law, was treated mainly in the term of law of the inheritance and succession. It provides a way of introducing an outsider into a family and so bringing him within the scope of the succession rules in modern system. Succession rights and the other obligations and the right in a case of adoption are usually treated by the analogy with those of unadopted children, and in some systems there is in an explicit equation which such children. Decision making. The older lies making countries treated decision making with regards to child as a private family matters in which the court should not intervene except in the case of a serious child abuse, or like in the English common example decision of the latter part of the 19th century carried the doctrine of the family will to considerable lengths by granting the father an autocratic position during his lifetime and even after, if a testamentary guardians was optioned upon his death. In a most developed societies, customary law gave similar authority to the father, through sometimes the custody and training of the girl was especially province of the mother. In modern law, the power of the father has yielded to the principle that the welfare of the children is the paramount, but his relaxation has raised important and difficulty questions. The prevailing views is that the court should be take justification and intervenes in family decision making when injustice, oppression, or cruelty might result. If they do not, the consequences seem to that it would be an extreme and the undesirable principle to make a parent child relation wholly private and exclude the justification of the court, but that it would also be extreme and undesirable to have a no private domain of a decision making, and to bring all family dispute to country. The partial rule lies between the extremes. The application of such rule is uncertain and there are bound to be difference of opinion. Questions of custody. Questions of custody cannot be determined solely by the deduction from a rule of law that requires the exercise of the judicial discretion that takes account of all the relevant circumstances, which may be very complex. In diverse such cases, the situation is often a de facto one of the separation of two the parents has taken place sometime before the legal proceeding, and the children is already in the custody of one of them, so that divorces decrees may do not more than regularize in the law what has already happened in fact. Some common law court have no occasion ordered joint custody whereby the non-custodial spouse is involved together with the custodial spouse in the decision making regarding the welfare, upbringing of child and other development of a growing importance in the use of some form of family consoling. In the question of a custody of a children, the basic argument in the favor of the approach is that a custody plans work out with the help of meditation and agreed to the voluntary by the parents is likely to have a greater success than a custody judgment imposed on the parent after litigation. I hope so that you have understand the today's topic. Please like, share, and subscribe my YouTube channel. Inshallah, we will meet in our next video. Till then, take care. Allah Hafiz. Bye bye.